Welcome to the fourth edition of Court Helicopter Explainer, which brings you today the glossary and the terms that are used in court, which you do not sometimes understand. We have had 3 episodes. This is the 4th episode, and we are going chronologically in the alphabetical order. Today we start with letter H. Letter H is very critical because it brings to you the question: when people are alleged to have been abducted, when people go missing, you hear lawyers talk of habeas corpus. When our activists go to Zanzibar, they go to Tanzania. The other day, there were 2 activists in Uganda. Then you hear habeas corpus. What is habeas corpus? And then you hear the term writ. What is a habeas corpus? Habeas corpus is an application to the High Court where somebody has gone missing, and that person who has gone missing is believed to have been taken by state agencies. That person cannot be traced in mortuaries. That person cannot be traced in police stations. It can't be traced in police cells. So one moves to the High Court, and the court issues the following: a habeas order. What does habeas mean? Is that the body of the person be produced alive or dead. That is what is called habeas corpus. Bring the body alive or dead. So the police or relevant officers are told, bring the police, bring the body of that person. So today you have learned, when your relative disappears, the first thing you go is to make a report of a missing person. But if you believe the missing person is not a missing person, then it moves to habeas corpus. Bring the person, the body, alive or dead. 2, we have what is called hearing. A hearing is a formal trial. Under Article 49 and Article 50, each person must be heard. Under Article 47 of the Constitution, it is called a fair hearing. Every person must have a fair hearing. A hearing can be in a court of law. A hearing must be in an employment situation. You cannot be sacked from employment without a hearing. You cannot be condemned and heard without a hearing. So that is what is called a hearing. An opportunity for the person who is being accused to come and face the accuser in court, in a tribunal, or before an employment issue. 3rd, hearsay. Very many people hear a term hearsay, that this is hearsay evidence. What is hearsay? Hearsay is evidence. 1, the person who wants to give that evidence is not the one who made it. It is another person. 2, he never heard the person speak. So that if it's Omari giving evidence, I will say, I heard Cyrus talk to me. A 3rd party cannot tell you to go and say it in court, where you are getting Cliff Ombeta saying, Cliff Ombeta, I was told by Nyaberi that this is no. Hearsay evidence is not admissible in court. It must be what you saw with your naked eyes, what you smelled with your nostrils, what you heard with your ears, and what you smelled with your tongue, and what you touched. It is only direct evidence, what you experienced yourself. Anything else is hearsay. For example, an incident happened in Isli. You were not there. Then somebody told you what happened. That evidence will not be taken seriously because you are not present, or nor did you see that. Then we move to letter I. Very interesting. Letter I deals with the question. Have you ever asked, sometimes you hear a matter has gone to court and the judge has said, send this file to the Chief Justice for empanelment. What is empanelment? Empanelment is a process where serious constitutional matters are referred to the Chief Justice for empaneling. Here, the Chief Justice can empanel 3 judges of the High Court to sit. She can empanel 5 judges, or she can empanel 7 judges of the High Court. Equally, the matter can be empaneled at the Court of Appeal by the President of the Court of Appeal. Normally, the Court of Appeal seats 3 judges or 5 judges, but the Court of Appeal judge, President, can empanel to be 7. So this is where there is an empanelment. In camera, you have heard the matters went in camera. What does in camera mean? In camera means only the parties are present. Members of the public are excluded from being in court. Members of the fourth estate, the media, are excluded from being in court. These are matters, for example, in matters of defilement, in matters of rape, in matters of divorce, in matters of family. Normally, these cases are heard in camera. 2, in matters that affect state security. The prosecutor will request the court that this matter touches of the national security. Then the matter will proceed in camera, not to jeopardize the security of the country. Then we have incompetency. Incompetent is a question of whether somebody is fit to testify or he is incompetent. Somebody can be incompetent because he's a minor. He cannot testify. He's incompetent because he is suffering from a medical condition that does not allow him to testify, like dementia. He's senile and he can't testify. So the question of incompetency can be there. Then we have also the question about infant. Any child below 18 years is an infant pursuant to Article 260 of the Constitution. That is an infant who is below 18 years. Then we have the most important issue. We have had the president complain every other day. Injunction. What is this thing called an injunction? The state says people are going to court and getting injunctions. What is an injunction? It is a court order, a temporal court order, stopping a certain action from being done for a specified duration. So if the government wants to build or demolish a house, you go to court and get an injunction to stop the government from demolishing that house because the house belongs to you. The court will issue an injunction to stop, a temporary injunction to stop that. If somebody is writing text messages abusing you, you can rush to court to get an injunction to stop him or her from posting some funny messages on social media until the case is heard and determined. So an injunction is a temporal relief to preserve what you wanted preserved for some time, or to stop something from being done until the parties have been heard and determined. Then we go to the question of inquest. What is an inquest? An inquest is normally when there is no sufficient and conclusive evidence to show who is the reason for the death, of a particular person. Somebody has died. It is mysterious who killed this person. The investigators, that's the DCI, the homicide, cannot be able to say it is so and so. The file goes to the DPP, and the DPP orders a public inquest. For example, the Jeff Mwadhi matter, where Court Helicopter has been recording and following the proceedings live. It is an inquest. An inquest starts with a file being opened. Everybody goes and records statements. Nobody is a suspect. Everybody comes to court. You give the story, what you know, the evidence you have. After that, the court that hears the inquest will make a finding and recommend to the Director of Public Prosecution that in this matter, one, there is nobody who looks culpable. Two, it can recommend to the DPP or DPP that so and so should be held liable, and the court recommends those people to be arrested and be charged. The final decision rests with the Office of the Director of Public Prosecution on a public inquest. So an inquest is a public inquiry, not by the police, but by the court. It is the court now that becomes an investigator instead of the DCI being an investigator. Then we have what is called interlocutory. Interlocutory, it is sometimes called interlocutory orders, interlocutory judgment, interlocutory proceedings. What does that mean? These are not conclusive. These are provisional. They are temporary. They are interlocutory. There is going to be a further hearing. So these are not final orders. This refers to decrees of the court that are preliminary. They are interlocutory preliminary proceedings. Therefore, interim orders are interlocutory orders. They are not conclusive. Judgments give final orders. Then we have intestate. When somebody intestate means somebody who has died without a will. That person dies without a will is called an intestate succession. When one dies with a will, it is called a tested will, a tested succession, that there is a will. That is part B of this explainer number 4. Part C, let us look at letter J. Letter J, we are dealing with what is called a judgment. A judgment is a final decision of a court. A final decision of a court. A ruling is on applications. Once an application has been filed and heard, the court makes a ruling. The court proceeds to hear the main case. A judgment is the parties who take the dock, present their evidence, and they are questioned. A judgment is the final decision of that court. Once the court makes a judgment, it becomes what is called functus official. That judge, that magistrate cannot hear that matter further. If you are aggrieved with an application, a ruling, you can apply to challenge that ruling before that court. But a judgment, once a judgment has been issued, that is final. The judgment of the Supreme Court in an election petition is final. You can't appeal it anywhere. A judgment from a magistrate, you go to appeal to the High Court. A judgment from the High Court, you go to appeal at the Court of Appeal. So that is the difference between a ruling and a judgment. A judgment is final. Once a judgment is done in a criminal matter, the person now waits to be sentenced. The judgment says he has been convicted of rape, he has been convicted of defilement. The sentence now comes later after he mitigates and is given 5 years sentence, 30-year sentence. That is final for that court. That is what is called a judgment. Jurisdiction. Jurisdiction is very critical in that each court, we have dealt with courts, each court has jurisdiction to hear matters. For example, the magistrates court has several jurisdictions. There is a criminal court that hears criminal matters. That time the magistrate is sitting as a jurisdiction of a criminal matter. In the civil court, jurisdiction of magistrates courts is pegged on the amount of money cases they can hear, what is called pecuniary jurisdiction. A magistrate's court, the chief magistrate, can only hear matters below 20 million shillings. Those are the matters that go under the jurisdiction of a magistrate's court. Any amount above 20 million, the jurisdiction is in the High Court. That is pecuniary jurisdiction. Number two, the small claims court jurisdiction pecuniary is up to 1 million shillings. If your claim is above 1 million shillings, then you go to a magistrate's court. Jurisdiction of the Kadhi's court is based on that the two people must be two practicing Muslims. You cannot take a Christian and a Muslim to the Kadhi's court. Jurisdiction is that they must be two practicing Muslims. Then we have what we call territorial jurisdiction. That the trial court, the court that hears this matter, must be the court where the offense was committed. So, if the offense was committed in Kisumu, somebody will be arrested in Nairobi and be taken to Kisumu, because that is where the territorial jurisdiction is. The High Court of Kenya has a national jurisdiction of the country. So the High Court in Kenya can hear any matter. You have heard matters of government being sued in Mwea High Court. Mara, they are being sued in Kericho High Court. The High Court has jurisdiction country-wide. And that is what is jurisdiction. If a court has no jurisdiction, the matter will be dismissed. The High Court, there is a law that deals with the organization of courts. Land matters, environment and land matters, the jurisdiction is on a court called Environment and Land Court. Family matters, the court that has jurisdiction is a family division under the children's matter. Commercial matters, they are heard by the division called Commercial and Civil Division. And corruption courts have courts that are identified as anti-corruption courts, and the magistrates are specifically gazetted to have the powers to hear jurisdiction of anti-corruption and children matters. Then we have courts that are specified as provided by that. So if you go to a wrong court, your matter will be dismissed. Labor courts deal with matters labor, and that is all. That will mark the end of episode 4 that has captured mostly the question about jurisdiction. Wakili Danstan Omari on Court Helicopter News. We have a duty to teach you the law. We have a duty to tell you to ignore gossip. Tune in to Court Helicopter News. Every Saturday and Sunday, we bring you what the law says. Thank you very much.